Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments. I have a great topic for you in the meantime. While I'm telling you about my topic, you just go ahead, put your questions in the comments. I will answer as soon as I finish introducing the topic. So today is when can you apply for adjustment of status? Now, for those of you who don't know, adjustment of status is where you are staying in the United States and you're applying for the green card. But not everyone who qualifies to apply for permanent residence is going to qualify to stay in the United States and apply for permanent residence through adjustment of status. So, who qualifies for this? So generally, it is going to be an individual who is here already on legal status and they're maintaining that legal status. In addition to that, they have a current priority date. That means that an immigrant visa number is available to them. And in addition to that, they have they also have a pending or approved I-130 petition. So if you meet those requirements, then you will be able to or may be able to apply for adjustment of status. That's the first group. And two very important requirements here is you are maintaining your legal status and you have an immigrant visa number available to you. But of course, in order to have an immigrant visa number available to you, you have to have an I-130, a petition, either an employment-based petition or a family-based petition that's been approved. So that's the first and it's the most common category. However, if you don't have current legal status, say you overstayed your visa, would you be able to apply for adjustment of status then? It's going to depend, right? No, it's going to depend on whether you fall within the exception, because remember, usually in order to apply for adjustment of status, you have to be maintaining your legal status. If you don't, there are only a few immigrants that can apply for adjustment of status despite overstaying their visa, and in some cases after crossing the border without permission. And I'm going to list these for you. It's going to be immediate relatives of U.S. citizens. Immediate relatives of U.S. citizens will be the spouse of a U.S. citizen, the parent of a U.S. citizen, and the U.S. citizen is 21 and up, or the son or daughter of a U.S. citizen who is under 21 and unmarried. If you don't fall within this category, then the next question is, if you do have this relative, but they don't want to apply for you. Also, if you have a legal permanent resident, spouse, or a citizen son or daughter, and they're mistreating you. So the U.S. citizen or legal permanent resident, spouse, a parent if you're under 21 and unmarried, or a citizen adult child 21 and up, they're mistreating you. They are subjecting you to extreme cruelty. That means that they're maybe willfully doing things to harm you, whether physical or emotionally, financially. Then you could qualify for what's called Vawa. And Vawa allows you to apply for your own status that will get you a work permit and then go on to permanent residence if your VAWA is approved. It's very useful for cases where these relatives are either they don't want to apply for you, or you can't go through the process because you want to leave the relationship with, and this is parent-child, this is spousal relationship. You want to leave that relationship, you want to be able to get away, and you need to apply on your own for immigration relief. So that's another one. Also, if you have T status or U status because you've been the victim of a crime or you've been the victim of trafficking, that can also be a path to permanent residence. So if you have a history of crossing the border without permission, or you have a history of overstaying, you could possibly still apply for adjustment of status through your T or U status. And then last, through asylum. So once you've received asylum, you would be able to adjust status after 1 year of having asylum. So those would be the exception if you do have a history of overstaying, or you have a history of crossing the border without permission. Those are ways that you could stay in the United States and still apply for permanent residence. Now, with employment, if you've already overstayed, it is going to be very difficult for an employer to be able to sponsor you. One, because if you have a current employer and you don't have status, but you're working for the employer, that means you're working without authorization. So that prohibits you from adjusting status. And then the other is that you can't adjust status without status under the employment category. So there would be two things against you. However, if an employer wants to recruit you and you haven't worked for them without permission, you've been in the US, but you have not worked without permission, it wouldn't allow you to stay in the United States and apply, but you could, if you have a US citizen or a legal permanent resident spouse or a parent, then you could apply for what's called a waiver for forgiveness to get your green card through employment, but you'll have to complete your interview at the embassy in your home country. It's a special type of waiver that provides forgiveness for the overstay so that you're able to leave the country and attend your final interview. That will be a topic for another day. So that's going to be it. I listed out many of the individuals who can stay in the United States and apply for permanent residence after overstaying. And if you are currently maintaining status, you have a current priority date, and you qualify through the I-130, then this could be for you, adjustment of status. You don't have to leave. You then could just get a head start on life. Remember, in the United States, remember the information I'm giving you here is not legal advice. It's general information. So be sure to schedule your appointment so we can talk more about your situation and whether you qualify. Now I'm going on to questions. Go ahead, put your questions in the comments. I'm monitoring the comments both on YouTube and on TikTok. So feel comfy, put those questions in. Hi there, Jay Hind. It's always nice to see you. I know, can we be able to file the 751 and N400 together? Someone is asking. That may be a possibility. Whether that person qualifies, they'll have to make sure they get a specific consultation. However, generally speaking, that is possible and that has been done. The officer, when you're called in for the interview, will first evaluate the 751. That's to remove the conditions on your 2-year to get it to the 10-year. And if all is well and they approve it, then they're going to go on to review the N400, go through the citizenship evaluation and test, and then tell you whether you are approved for citizenship as well. Hi there, I'm an arriving alien. Could I go for adjustment of status? I'm married to a US citizen. So I wouldn't be able to tell you specifically whether you can go ahead. I would have to understand what your situation is. You said you're arriving. What does that mean exactly? Does it mean that you came in yesterday? Now, generally speaking, citizens, spouses of US citizens qualify for adjustment of status, but I would want to understand, when did you come in? What were the circumstances surrounding you now considering adjustment of status and so forth? Okay, how long does it take to get the interview in Juarez? So you're looking at anywhere from 3 months to even over a year for the interview. Jay Hind, you're welcome. All right. So keep putting those questions in the comments. As long as I'm here, I am monitoring your comments and I will answer the questions that are coming in. Your question can be anything that's immigration related. So put those questions in the comments, and thanks so much for the love. I appreciate it. So there's one thing I'm going to add here is when you know that first of all, if you schedule the consultation, we confirm that yes, you do qualify for adjustment of status, then the next thing is to prepare it. The advantage of the adjustment of status process is that you get a head start on your life in the United States. That means you could get your work permit while staying and waiting for your process to be completed. You could even apply for your travel document that would allow you to leave the country if necessary. Now, what we do is we file there are various forms that need to be filed, the petition, the underlying petition. So that's either going to be related to employment or family, or it's going to be related to a humanitarian relief like the asylum or TRU adjustment of status. Then we also include the work permit application, travel document application, and if required, the affidavit of support. For some of these, the affidavit of support is not required, like for Vawa, for the T and the U. How long does it take to renew your green card when it expires? So right now we're looking at a year, believe it or not. And that's for just a regular expiration. If you're talking about going from the 2-year to the 10-year, you could be looking at over 2 years. How long the AOS is taking right now, I'd say prepare for 18 to 24 months. It could be shorter and it may even be longer, just depending on what kind of developments happen in your case. Great questions. Keep putting those questions in the comments. Now you can go to the link in the profile and it's going to take you to the website where you'll have the options to call, to fill out a contact form, or to speak to the scheduling coordinator through online chat. All three will lead to the scheduling coordinator and they'll be more than happy to assist you. If you'd like to schedule your own appointment without calling, just go to the contact us page and go through the form and confirm your appointment. If my dad, who was a US citizen, died in 2013 but didn't file for me, can I file for myself? So no, it's not going to be that straightforward. The question is, what happened? Your dad died in 2013. I'd have to figure out what happened. What was your relationship like? Why didn't he file for you? Another thing though is that even he died in 2013, and even if you qualify for VAWA to apply on your own, it has to be the limit is up to 2 years past your dad's death. But another thing to consider here is, did you derive citizenship from your dad? Now, it sounds like you don't have lawful status in the United States. My next question, though, would be, so you may not have derived citizenship, meaning you may not have automatically gotten citizenship from your dad. But my next question is, when you were born, was he a US citizen? Because that could also indicate that you may have gotten citizenship already. While I can't tell if you're anywhere close to that, that's because I haven't evaluated your facts. This is why it's important to schedule personal consultations to see if you do fit within any of those boxes. EOD under I-485, how long is it taking at the Vermont Center? So you're looking at anywhere from 3 months to 12 months. My friend is married to a US citizen. They filed adjustment of status last August. She was on his insurance, but he changed his job. Okay, so those are very specific circumstances. I wouldn't be able to, she had surgery to remove her thyroid. So can they expedite her case? I wouldn't be able to tell you that because I'm not the attorney. I only do expedite requests for my clients. I don't do it on an individual basis, but if there is, so it's usually based on an urgent humanitarian need that may include the fact that she's had surgery, but I wouldn't be able to tell you for sure whether she can expedite it. just based on the information you've given me. Could you get married to someone who's waiting to receive the green card that they want to renew? So whether you need legal advice, or the person who's doing this needs legal advice. Getting married to someone who's waiting for their permanent residence can affect that person's eligibility for the green card. So for example, if a parent is sponsoring their adult child, and the adult child is unmarried, they're filed as unmarried. Once they get married, they're no longer eligible for the benefit as an unmarried child of a green card holder, for example. Now, if they're already a green card holder and they're just waiting for their renewed green card, then that may be a different story. But this is a very, very specific question. And so it's important for you to make sure you or your friends schedule a consultation. I came through one of the ports, asked asylum, and they let me in. Then I was considered arriving alien. Okay. Your visa, why I got a work permit already for more than... I'm not sure, Montu. I'm not sure. I'm not your attorney, so I wouldn't be able to tell you that. Why, Yuri, thanks so much, and thanks for tuning in. Thanks for listening. I really appreciate it. Happy Ramadan to you too. Thank you. So what I'm going to do now is I'm heading on over to Instagram. So you can join me over there in a quick minute. I'm the immigration attorney on Instagram. If you can't join me there, you can go ahead and join me tomorrow at around 4 p.m. Eastern time, where I'll answer your questions. But I do also schedule lives at 4:30 p.m. on Instagram. So I want to be sure that I can meet that commitment, but you are always free to join me there. Wahuri, I'm heading on over to Instagram now. I'm the immigration attorney on Instagram. If you want to follow me there and join me on the live in a minute, that would be great. If not, you can catch me tomorrow at around 4 p.m. Eastern time. So, and you can catch me at that time, Mondays through Fridays. All right, so have a great one in the meantime. I will see you tomorrow. Hopefully I'll speak with you in a consultation. Just go to the link in the profile, go to the link in the About page on YouTube, and it will give you everything you need to schedule your appointment. Have a great evening. I'll see you tomorrow, or I'll see you on Instagram in a quick minute. Bye-bye.